the matter of Freedom and Freedom Travel Group Ltd.
Mr. Orton.
May it please your ladyships, I appear on behalf of the appellant together with Mr. Archer, who sits behind me, and Mr. Riley Smith, King's Counsel, appears together with Ms. Moses on behalf of the respondent.
Thank you very much. Mr. Orland, if it helps, we've had the opportunity and taken it to read the core bundle and obviously to dip into the authorities and supplementary bundle.
I'm most grateful, my lady. This, as you'll know, is an appeal from the decision of His Honour Judge Simpkiss, King's Counsel, sitting in the Brighton County Court on the 4th of September, when he dismissed our first appeal from the decision of Deputy District Judge Campbell, whereby she in turn dismissed an application to join the respondent pursuant to CPR 19.5. By this appeal, we seek an order allowing the appeal and granting permission to join the respondent to these proceedings pursuant to that provision, and then directing that the claim be relisted for a costs and case management conference. By way of two matters of housekeeping, my lady, we have agreed, subject to your ladyship's approval and of course interventions, that in principle we're working to a timetable of 2 hours each. I will open for 2 hours maximum. Mr. Riley Smith will respond 2 hours maximum, and that leaves a short time for reply and slippage.
That's very, very, very sensible, thank you.
And the second point I just wanted to check is that your ladyships have all received an email sent clarifying the position in relation to the Respondent's Notice yesterday. No further point is taken on.
No, we have. There is another point of housekeeping if you finished your list.
Certainly.
It's just to check that we only have one skeleton argument from you. I don't know if you filed a supplemental at all.
No, we didn't.
No. Thank you.
You do. That's in tab 2 of the court.
It is. It is.
There's only one point that doesn't deal with. So I'll deal with the subsidiary, the additional point orally, and quite shortly at the end of my submissions.
So be it.
And in fact, it's almost enveloped in my submissions in any event, which is why we didn't file a supplementary skeleton argument, because we felt it was otiose. But the only other point that's not dealt with in the skeleton argument that you read is the point on ground 2.
Yes, quite.
Where we will refer you to the original skeleton argument, but again, I will summarise that position for your ladyships orally in due course.
Yes, we'll get to it when we get to it.
Indeed.
In other words. Yes, all right.
And you do deal with it in some detail in your original skeleton argument.
We do, my lady.
Yes.
If it pleases your ladyships, what I propose to do is summarise the argument for the appellant in essence, outline how I propose to develop that argument so that your ladyships all know where I'm going, and then proceed to develop it in that way.
Thank you.
My ladies, the argument for the appellant is that the learned judge, with the greatest respect to him, was wrong in law to find that the appellant has no claim pursuant to Section 75 of the Consumer Credit Act. We say Section 75 is an extraordinary section which, and to adopt here the words of the section itself, in relation to a transaction financed by the agreement, does two essential things. It imposes on a creditor joint and several liability with the supplier to a debtor in respect of any misrepresentation or breach of contract for which that supplier is liable. So it thereby removes in one fell swoop the immunity that a creditor would otherwise have pursuant to the doctrine of privity of contract. And its very scope, we say, emphasises the fact that the purpose and policy underpinning the Act was one of consumer protection. Section 75 must, of course, be read in conjunction with Section 189, where we find the definition of debtor. Here we say that definition is not, as the respondent suggests, very narrow, in other words, confined to a contracting debtor, but wide, and it does not expressly rule out a debtor of the kind for which we contend. And taking the two together, we say that on a proper construction, section 75 with section 189, Mrs. Cooper was a debtor in that, and we put it in two ways. First, she received credit under a Consumer Credit Act agreement, albeit we accept not an agreement with her as opposed to with her husband. Alternatively, we say that the law operates to pass the rights of Mr. Cooper to her in this circumstance. And by this circumstance, what we mean is this, and this is important for your ladyships, as to the scope of section 75 for which we contend. We contend that it does apply to any person where a credit card has been used to pay for a contractual service or contractual goods. The claimant has his or her own claim for breach of that contract against the supplier. But that claimant is not the contracting debtor or cardholder.
Sorry, the meaning of what? The meaning of section 75?
Yes,
Right.
taken with section, obviously section 75
Taken with
has the word
189.
debtor, and you need to take that in conjunction with section 189. But for the purposes of section 75, effectively the removal of privity of contract to impose a joint and several liability, we say it should be expansively
Is there
construed.
any limitation on that expansion? So would it just
It
be
is.
wife, children, grandchildren?
What we say is that it is anyone who has a claim in contract against the supplier. So, for example, so the answer, and it's a very pertinent question, which is why I'm outlining our position in opening. So, for example, if a credit card was used to buy a gift for a child, and the gift was faulty and the child was injured, the child wouldn't have a claim in contract against the credit
No,
card.
well, that's a gift. But for example, if Mr. Cooper, to celebrate a particular birthday or anniversary or whatever, had decided that he was going to take his family on holiday, there would certainly be duties of care applicable to all members of the touring group. So would the ability to make a claim, as Mrs. Cooper hopes to do, extend to each and every member of the family?
Not necessarily. It would only so extend if the claimant can show that she can sue on the contract.
Why do you tether yourself to the contract?
I'm sorry, my lady?
Why do you tether yourself to the contract, as my lady says?
Because
What's the principal distinction in the ability of
Because
Brown
it's-
Child to sue by reference to the contract?
because you have to have a claim in contract to have a like claim under section 75.
So Mrs. Cooper's contract was facilitated through her husband's credit card, but you say that the contract relating to the package holiday was with both, because both of them had tickets, because both of them were named on the
Because by
application?
law, she has a contractual right to sue for any breach in her own name. And that is the effect of the council directive coupled with the package travel regulations.
Right.
Well, before we even get to the regs and the directive, let's go back to section 75 so that I properly understand your argument.
Yes.
You say by law she has a contractual right to sue for a breach of contract. Are you saying that right is given to her by section 75?
No, to sue the supplier, no. That right is given to her by the package travel regulations.
Right.
By the 92 regulations.
Exactly.
Can we go there? Because I'd
Certainly.
like to see exactly how you're saying that this
Certainly, my lady.
provides the...
So this
Yes,
is volume 2, tab M. Would it help if I took your ladyship first to the directive, or should we start at the package travel regulations, which it comes to the same thing. The provisions are imported, but I can give your
Yes.
ladyship the references for
Yes.
the directive in due course.
Yes, of course.
So at tab M, my lady,
Yes,
we start at 375.
yes,
And you'll see that this is Regulation 2,
yeah,
Interpretation. The first definition that is important here is contract.
yes,
And I invite your ladyships to read that. It is the agreement linking the consumer to the organiser, or retailer, or both. And then if you drop down a few lines, you'll see the other party to the contract. That means the party other than the consumer to the contract, that is the organiser or the retailer or both. And then if you turn over the page, my lady, this is Regulation 2.2.
yeah,
In the definition of contract in paragraph 1 above, consumer means the person who takes or agrees to take the package, the principal contractor.
And that was Mr. Cooper.
It was. There's no dispute about that. And elsewhere in these regulations, consumer means, as the context requires, the principal contractor, any person on whose behalf the principal contractor agrees to purchase the package, the other beneficiaries, or any person to whom the principal contractor or any other beneficiaries transfers the package, the transferee.
We know that Mr. and Mrs. Cooper went alone, and we know that they're the only two named on the invoice.
Indeed.
So what if they had gone with a friend or a cousin or a relative of some sort? Would that other person be a beneficiary for the purpose of
Yes.
2.2?
Everyone who is named as a party member to a package holiday under these regulations.
But if not named on the invoice,
there might be, there would probably be argument about that.
yes,
but that would cover grandchildren.
But I would say that this construction is wide enough to construe anyone who, in fact, is a member of the party and a beneficiary to the contract.
Well, why did you say that it wouldn't cover grandchildren?
I'm sorry?
Why did you say, when I asked, that it wouldn't cover grandchildren because they weren't party to the contract?
Because I understood the proposition your ladyship was putting to me wasn't governed by the package travel regulations.
Sorry, I'm going to have to row back on that. It was obviously my fault then. So if we had the situation that Mr. Cooper, as he did in this situation, decides that he is going to celebrate an anniversary.
Yes.
And they want the family to be with them.
Yes.
And so they make contact with Thomas Cook, whichever package operator they're going to use, and they say, we want 4 bedrooms in Hotel Costa del Sol. And inevitably they name the participants of the group. All of those would be covered by the regulations.
They would.
Even though they weren't party to the contract.
Absolutely. And
So-
that happens week in, week out in package travel regulations.
Yes. So I'm sorry, I don't know what part of the question that I asked you prompted the response then, because you said that they wouldn't be covered because they weren't parties to the contract.
As I recall, your ladyship didn't preface your question by making clear that the contract was governed by the package travel regulations.
Oh, well, I'm sorry. that's
My
fault.
point is that anyone who is deemed or is either in contract or is deemed to be in contract and therefore has a contractual claim in their own right,
Mr.
we
Roberts,
say...
I'll blame you, you blame me. I understand the point now.
Thank you.
Yes.
Lady, could we then, while we're there, could I just take you to save having to come back here? Could we go to Regulation 15
Yes.
to make good the argument? And it's Regulation 15.1. the other party to the contract, so that's here the tour operator, is liable to the consumer for the proper performance of the obligations under the contract. And as we've seen, that consumer includes all beneficiaries, whether principal contractor or otherwise. And that is the provision which gives all members of the party to a package holiday contract the ability to sue in their own name, taken with Regulation 2.
But the purpose of these regulations is to provide protection to consumers who are part of a package holiday.
Yes.
That is a very different purpose to that of the 74 Act, which is to provide protection to consumers in respect of a credit agreement. There is quite a distinction.
There is, but they follow very similar patterns, my lady. Both effectively remove privity of contract to provide a wide-reaching aspect of consumer protection. That is to say, the ability of a consumer to effectively get home, to establish a liability or a breach of contract against someone who would not otherwise be, who would be immune from suit through privity. And furthermore, the package travel regulations go further than that, because there is a secondary level imposed of liability, which is that they can sue, by the provisions I've taken you to, the tour operator or the travel agent for any of the that agent or tour operator's subcontractors or suppliers. So there are two levels on which effectively privity of contract is removed. And we say that the Council Directive and the Package Travel Regulations, part of that, an aspect of that protection provided by that legislation, was to guard against insolvency of the tour operator, supplier. And so we say that to achieve that end, adopting Mar leasing principles, Consumer Credit Act 1974 should be construed purposively to achieve that end, in addition to our other arguments. But our primary argument is that the grounds for saying as we do and defining debtor as we do for the purposes of Section 75 are first clear from the language used in the sections. Second, reflect the purpose of the legislature in passing this legislation,
Which
namely
legislation?
the Consumer Credit Act, namely consumer protection as far as Section 75 is concerned.
Well, that is consumer protection in respect of a credit agreement.
Absolutely, my lady.
Let's not forget that.
No, I'm not forgetting that. The key, though, is whether for the purposes of Section 75, that protection extends to a debtor who is someone other than the contractual debtor under the Consumer Credit Act agreement. And we say our argument is supported by commentary by Sir Roy Good in his analysis of this section. It is consistent with an expansive interpretation adopted by the House of Lords in relation to Section 75, albeit on a completely different aspect of it in the OFT case. And coupled with that, we then submit that adopting Mar leasing principles, looking at the aims of the European legislation, the interpretation of Section 75 should effectively ensure that the consumer protection which that European legislation envisaged is achieved. My ladies, with that outline, if that helps, I propose to develop it in 5 sections, essentially. A brief summary of the factual background, which I will skip through, given your ladyship's helpful indication that you've read the core bundle. Then I will take you to the relevant background material, that is to say the Crowther report and the second reading of the bill and some remarks of Sir Geoffrey Howe in introducing that second reading on Hansard. I will then take you thirdly to the relevant statutory provisions themselves and expand our interpretation of them by reference to both case law, that's the OFT case, and the European Directive and the PTR, which I've taken your ladyships to already. Then I will take you to the commentary of Sir Roy Good. And finally, I will deal with ground 2 at the end. It will be apparent to your ladyships from that outline that I do not propose to take your ladyships to the authorities on statutory interpretation. As is apparent from our respective skeleton arguments, there is very little disagreement between us as
Some
to...
disagreement about your ability to refer to Hansard.
I didn't understand that there was a disagreement about that, my
Well,
lady.
I got the impression that there is an issue as to whether or not it's necessary for you to refer to Hansard on the basis that this is not a provision that is in any way ambiguous.
That point is exactly the point of dispute, namely whether, as Mr. Riley-Smith says, to get to purposive principles, I need to show that it's not ambiguous, and that is the only point of disagreement between us.
Well,
May I take...
That's why I pointed the issue out.
Indeed.
But in any event, we'll get to that in due course, Mr. Alden, because I don't want to throw you off your schedule, which looks very good.
My lady, may I give your ladyship the references that we say, and if time permits, I will take you back to the 2 passages in Benyon and one of the authorities, which we say show that it's not a threshold that I have to overcome.
Well, I tell you what, Mr. Alden, subject to my lady's agreement, and they're not likely to be shy in coming forward, I think that we should just hear you. And then we'll hear, obviously, the response, which will include, and we've seen, as you can see, the issue being raised. We can determine that in the course of our judgments. And if we're not going to allow you to have reference to it in real terms, we can deal with that then.
I'm grateful, my lady.
I think that will save time. My ladies agree. Mr. Riley-Smith, you're happy with that? Yes.
Thank you, madam.
Does that suit you, Mr. Alden?
Yes, absolutely.
Yeah. Okay.
Many thanks. My lady, could we then take up volume 3 of the authorities bundle? And your ladyships will find the Crowther report at tab Q, which is where I propose to start. And this part of the report, it underpins what then became the section 75 ultimately. And it's split up on the first of these pages, 531, a section obligations of the connected lender, and then on the second page, liability of connected lenders. And if I can take those in order. In paragraph 6.624, may I first invite your ladyships to read from 7 lines down, but where a lender is connected, is a connected lender, to the end of the paragraph.
Do we need to understand what a connected lender is?
I don't think it's in dispute between us for the purposes of this appeal.
That what?
That it's not material to this appeal in the sense that it is agreed between us, but the agreement in question, that's to say the agreement with Mr. Cooper, was a creditor-debtor-supplier agreement for the purposes of Section 75. So, my ladies, under this paragraph, this is the discussion on how the provisions or how the protection is designed to override problems of privity of contract and give the debtor or a debtor a remedy against a second party who will then be jointly and severally liable. Pausing there, of course, it is trite that in this case, only Mrs. Cooper can enforce the contractual right. Mr. Cooper cannot enforce her claim. In the second paragraph, the committee report goes on. There are many reasons why, in practice, a legal right which the buyer may have against his seller is not sufficient protection. And then there's a discussion which ensues, perhaps if your ladyships pick up 5 lines on, the buyer supplied with defective goods, and then read to the about 10 lines down to a contract entered into with a third party, 5 lines up from the bottom.
The bottom, the second half of this paragraph deals with problems that simply don't arise in a holiday type situation.
Well, it deals with the point of liquidation, company going into liquidation.
Yeah.
And that's the essential point that I'm inviting your ladyships to have regard to. And then if we go over the page, my lady, liability of connected lender, the committee here in the first top paragraph contemplate 3 different ways in which the relief might be given to a borrower against the lender. And you'll see that the first of those is essentially the widest, and that is the widest protection that they recommend. And I'll invite your ladyships to read that paragraph.
So the whole of the paragraph, or just the first, which they recommend?
No, the whole of 6626, please,
Yeah.
my lady.
Okay.
Your ladyships will have noticed that the financial institutions promoted the third most restrictive level of protection. But as you'll see from the first sentence in the next paragraph, the first was recommended for adoption, and the other 2 were essentially not viewed to give adequate protection to the borrower, and that you'll see from about 8 lines down in 6627 by reference to the third alternative, although by implication it must also apply to the second alternative. May I take your ladyships now to the second reading of the bill, which your ladyships will find at the 4th tab no, sorry, not the fourth tab of this. Tab P, the previous tab. Page 534. The way this section is set out is there's a general introduction from Sir Geoffrey Howe, who was then the Minister for Trade and Consumer Affairs, as to the purpose of the bill, and then there's a long and detailed analysis section by section of the different draft sections of the bill. And it's the opening paragraph that I invite your ladyships to read first of all at the top of 534, please, which emphasises consumer protection aims of the legislation. May I then invite your ladyships to turn over the page and read the highlighted section, the second and third self-contained paragraphs on that page, please.
It's interesting, isn't it, the reason given for the width of the definitions in the bill is in order to keep pace with commercial developments,
Yes.
rather than for any other policy reason. So it's for fear of not wanting to keep up with the pace of change in terms of financial instruments and funding and that sort of thing. That's the reason for the width of the language used.
Certainly, my lady. And at that stage, of course, the market was in relatively nascent period of development.
Yes.
I accept that. In the second of those two paragraphs on 535, your ladyships will have seen that it was the intention for the definitions to be drafted as widely as possible, for the reason that my Lady Justice Carr has just raised, namely matters of detail that the market conditions and even policy considerations, we would say, would develop. So, of course, this was 1974, long before any European legislation such as the Council Directive came into force. And so that counts against, we say, the submission made by the respondent that the definitions are to be narrowly construed. And Sir Geoffrey Howe here reiterates that effectively there should not be, and this is the bottom of the next paragraph, the bottom of the third, the same paragraph, there shouldn't be any effectively loss of protection for consumers due to new and subsequent developments.
This is the final paragraph, the final sentence of the third paragraph on the page.
Yes,
that you're referring
exactly.
to.
By the second hole punch.
Yeah, the definitions in the bill are drawn as widely as they can reasonably be, and provision is made for regulations to be made under the statute covering many important aspects of the business.
And I think
And
the
then
sentence you were referring to
is
is
the
the final one in the next
It
paragraph.
is by the second hole punch.
Right.
The next paragraph, my lady.
Oh, I see, yes. So, no intention that lack of legislative time should any longer be a constraint on making proper provision for regulating new types of business, nor will it lead to loss of protection for the consumer as a result of new developments.
Indeed.
Yeah. So it's the final two sentences.
It is, my lady, thank you. My lady, may I now take your ladyships to the sections themselves?
Please.
Starting, so this is Authorities Bundle 2 at tab L, first tab, and the starting point is section 75, which is on 334. And taking it in, breaking this down, provision provides as follows. If the debtor, and that is obviously central to the dispute between us, under a debtor-creditor supplier agreement falling within section 12B, that is not in dispute between us, or C, has, in relation to a transaction financed by the agreement, any claim against the supplier in respect of a misrepresentation of breach of contract, he shall have a like claim against the creditor, who with the supplier shall accordingly be jointly and severally liable to the debtor. Now, insofar as the words in the first, after debtor, in relation to a transaction financed by the agreement is concerned, it is agreed that, of course, the appellant has a claim against the supplier, but, of course, Mr. Cooper does not. He cannot bring any claim for injuries on her behalf. Only the injured party can bring that claim. The key issue in dispute is whether Mrs. Cooper can be defined, falls within the definition of debtor. And for that, we need to turn to section 189, which starts on page 362. And it's simply to draw your ladyship's attention to the preface, where it says at the top under definitions, in this act unless the context otherwise requires, before listing a number of definitions. And what we say there is there's express acknowledgement in the statute of the possibility that a debtor may have different meanings in different contexts. And we say it does. We say the context of section 75 is unique. But we quite accept that our construction of debtor would not be appropriate for the various sections to which Mr. Riley-Smith refers, insofar as to illustrate that it can't be her for the purposes of serving notices, getting signed copies of the agreement, and so on and so forth.
Within one statute, the same word means different things.
Yes.
I see. Are you saying, just taking that point up, that the meaning you are attributing to it within section 75 is the only section within the statute that bears that particular meaning?
Yes, my lady, because the section 75 is a unique section.
So the context is absolutely key, as are the words unless the context otherwise requires.
Indeed. And that's why I opened the appeal on the basis that section 75 is an extraordinary provision. So then, if your ladyship's turn...
Sorry to butt in, but if it is an extraordinary provision and thus debtor is to be defined extraordinarily, would you not expect that to be spelt out in the statute?
Well, I say it's the
extraordinary result.
I say it's not extraordinary in the context of once one has accepted that Section 75 has provided a very wide-ranging statutory provision overriding privity of contract to achieve consumer protection purposes, the consequence of that is not extraordinary. But I say the provision per se is extraordinary. So once that has been legislated, it is not an extraordinary consequence to say that debtor for that purpose is to be widely construed.
I mean, if you take context aside, you would accept that Mrs. Cooper couldn't possibly fall within the word debtor. She owes nothing. She owes nothing.
So, precisely. So for the context of the sections which Mr. Riley-Smith refers you to, services of notice, copies of the agreement, signatories to the agreement, I quite accept that obviously isn't including her.
Is there anything in Benyon about having the single word in one statute having different meanings?
I'd need to check that, my lady.
I suspect there is.
Yeah.
We've got a huge chunk of it.
We have.
I'll have a look on that. That would be helpful.
No doubt my junior will beaver away while I'm on my feet.
Thank you very much. Thank you.
Could I was taking your ladyships to debtor on page 365, if I may. It's the top of the page. Debtor means, and for present purposes, your ladyships can ignore the square brackets.
Well, can we?
No,
Because the
no.
fact is, Mr. Ortland, it does specify explicitly an exception to the definition of debtor. So, taking up my Lady Justice Carr's point of view, why wouldn't it indicate? In fact, I think, forgive me, it's my Lady Justice Nicola Davies's point. Why wouldn't it indicate in square brackets, except in relation to Section 75?
Because the meaning, I say that's not necessary, because the words that follow include, when read in conjunction with Section 75, the words that follow include Mrs. Cooper.
Because she is an individual receiving credit.
Precisely.
I see.
And she has to be the individual receiving credit under a consumer credit agreement, or the person to whom his rights and duties under the agreement have passed, 1 by assignment or 2 by operation of law. And it's the second of those that is our alternative case. But in this context, in terms of who receives credit, it's important to bear in mind the definition of credit for the purposes of the Act, and that we find at page 315, section 9 of the Act. Under section 9.1, in this Act, credit includes a cash loan and any other form of financial accommodation. And we say that is very widely drafted.
Can I just bear with me for a moment, Mr. Ortland? The words that you say cover Mrs. Cooper, the individual receiving credit under a consumer credit agreement, does not impute the individual receiving benefit of credit under a consumer credit agreement.
Well, we say it does.
Yeah.
And that's Mr. Riley-Smith's point.
Yeah, but why not say it specifically? Anyone who is to benefit from credit received by another under a consumer credit agreement shall. And why is it necessary to have the assignment of rights?
Can I deal with the first point?
Yes, of course.
As to the first point, I say the argument can be turned on its head. And in the OFT case, what the House of Lords look at is whether what the respondents were saying should not fall within the definition of Section 55 was ruled out by the wording. And it wasn't. So in reply, my point is, if it was intended to exclude Mrs. Cooper, it could so easily have said so. By tightening up what is said to be receiving credit under a consumer credit agreement and spelling out that it is only a contractual debtor who gets the benefit. But it doesn't do that.
Right.
And when read in conjunction with Section 9, my lady, we say any other form of financial accommodation is so wide and certainly includes what we say is the situation here, namely, effectively a joint purchase paid for by Mr. Cooper, but effectively she is the beneficiary of the credit being extended. She is in receipt of that credit as much as he is in reality.
But can I just reflect back to you something that you said in answer to a question I posed quite early on, when you said that if someone received a gift, they couldn't have the rights of action that Mrs. Cooper seeks, because obviously they wouldn't be subject to the contract. But a beneficiary isn't necessarily a subject of I mean, you say that Mrs. Cooper is assigned a contractual role by the package operator.
No.
Regulations, but I mean.
Sorry, but yes.
Yes. But on your definition under Section 75, you wouldn't need to go there. You'd just say she's a beneficiary. It doesn't matter whether this was a gift to her, this holiday from her husband, or whatever.
No, it does, because she has to have a claiming contract to get home. She has to have a claiming contract against the supplier for liability to arise under Section 75.
So that it's only the
If we
package,
go back to Section 75.
yes, that saves the grandchildren. I see.
Precisely.
Okay. But you were going to give me the answer to my second question, which was, why would anybody need to assign rights and duties under an agreement? Because they could always be under the term an individual receiving credit.
Because, as we'll see, when we come to look at the commentary in Sir Roy Good's work, he envisages situations whereby third parties, as he calls them, fall between two stools.
Right.
And that we are precisely in that situation. And assignment could be one way of getting around the problem. The problem we have here, the appellant has here, is that, and I'll take your ladyships to it in due course, but effectively, when Thomas Cook went into liquidation, that route was attempted. So Mr. Cooper purported to assign his rights.
That's used against you, isn't it?
It is. Well, it's used against us, but it's interesting to note that as soon as that happened, out came the terms and conditions, which say that as a matter of contract, you cannot assign your rights under the agreement. So although that is one route home that Sir Roy Good postulates as a possibility, it's actually excluded by banks in the terms and conditions. They effectively provide that a consumer can't do this.
Right. Okay.
So it's not a route home in reality because of the terms and conditions of the contract.
So would it ever come into play?
I very much doubt it in these circumstances because I assume the contractual terms which are imposed by the banks, the consumer has to accept those terms, and it prohibits the right of assignment.
In order to get credit, in other words, they sign away their rights under the act. Yeah. Okay. All right. Thank you.
So, my lady, what we say is that, first of all, we say she is the individual receiving credit under a Consumer Credit Act agreement, albeit his Consumer Credit Act agreement. And she, we say, is deemed to have the contractual claim against Freedom Travel Group by the package travel regulations. We also say that it is known, it cannot be said that lending institutions do not know that when a credit card is used for the benefit of a joint purchase or a family purchase, the reality is that they are extending, they're maximizing their credit. They are getting a benefit. The more credit, the more profit. And what is effectively being said is that the banks should get the benefit of that reality without taking the burden. And we say that must be wrong. And we say that because ever since, in this particular case, and one has to see why it is said that Mrs. Cooper has a claiming contract. In this particular case, the package travel industry is huge and has been even before the package travel regulations came into force. One family member buying a package holiday for all family members happens day in, day out, sometimes on credit. But when it happens on credit, the credit card company can't say that the reality is they're extending credit for a price which covers 5 or 10 people, not just to him. They get the benefit of maximising the credit they are providing. Now, my lady, we've looked at the package travel regulation, so I've no need. I was going to take your ladyship to it at this point, but I've no need. May I give your ladyship simply the references to cross-refer to the council directive? They don't add substantively to the argument because, as you would expect, the provisions are carried through. But the references I would like your ladyships to have regard to, and this directive is at Authorities Bundle 2 tab N, are the 8th to 10th recitals, that is page 439.
You don't want us to look at it now?
Well, I'm very happy to take you. It's probably easier in case they're not marked up.
I think it is, don't you?
May I do that then very quickly, my lady, and you'll find them last tab in the same bundle. So 439, the first page for the recitals. Yeah. And they're not numbered, they never are, which is always a pain when it comes to council directives. But 8, 9 and 10 are the 3 last self-contained paragraphs in the second column.
Where is this disincentive?
That is 9. The one above is 8, the one below is 10.
So good reason then to take us there.
Indeed.
Okay.
And these essentially recite the purpose underpinning some of the provisions in this directive.
The anterior paragraphs echo what you've just been saying and help you, don't they? The importance of tourism and that supports the theme you are.
Indeed, it's a huge market, both for tour operators and for credit suppliers.
So do you want us to include those?
It doesn't.
Those recitals?
My lady, by way of background, it's very helpful. Right. But it doesn't, insofar as I'm inviting you to take from the combination of the council directive and the package travel regulations, the purposes were, 1, consumer protection, and that is against a background of a huge market. Also to provide harmony across all European jurisdictions, of course, insofar as that protection is concerned. But another is also insolvency. And for that we need also to look at articles, well, the insolvency article will come to last, but first may I take you over the page to articles 2.4 and 2.5, where we see the European definition of consumer and contract at the foot of the right-hand column.
Yeah.
Article 5.1, if your ladyships turn forward 2 pages to 442, top of the right-hand column, that is the provision which then carries through to Regulation 15.1, which I've taken you to.
Sorry, could you just give me that reference again?
Yes, Article 5.1, my lady, at the top of page 442. And then over the page, Article 7 is the provision relating to insolvency.
Sorry, does that carry across to a particular regulation?
It does, my lady. Just give me a moment. It's page 391, my lady, previous tab, Regulation 16. Also, incidentally, 17, which is about bonding requirements. And arising out of that, if I could ask your ladyships to put that bundle to one side and up...
Before you leave that,
certainly.
I'm just concerned that I may be missing a point, but this appears, the insolvency point, is it confined only to repatriation or is it wider?
Also to refund of monies.
Yeah.
The previous.
So it's refund of monies and repatriation.
Indeed.
So that is the context of insolvency.
It is, and I accept that that has to be taken at face value. It goes principally to those two aspects.
Well, you say principally. Is it principally or only?
Well, can I take your ladyship to the decision of the Court of Europe, the Court of Justice?
Yes, you can, but if you'd just be so kind for one moment, Mr. Rodland, if you can just look at 16.1, the other party to the contract shall at all times be able to provide sufficient evidence of security for the refund of money paid over and for the repatriation of the consumer in the event of insolvency. That doesn't seem to me principally.
No, I accept that, my lady.
Right.
Yeah.
So that is it.
Yes.
Thank you.
May I take your ladyship's authorities bundle 1, please? And this is the authority of Blurdle Paulick at tab E. And it's 19 and 20 on page 132 in the judgment of the court.
Well, that makes the same point.
It does, my lady.
Yeah.
Now,
Right, okay.
my lady, what we submit is that this legislation, the Council Directive, provided for a high level of consumer protection in a way which is somewhat analogous in terms of removing privity of contract to the Consumer Credit Act.
Sorry, this legislation you're talking about?
The Council Directive and the Package Travel Regulations.
Right.
And that is a market which has obviously developed, and a body of legislation that has developed since the 74 Act. And we say that taking the two together, where a holiday is purchased on a credit card, and it is known by the credit card company that frequently one person will buy the holiday for the benefit of others, and all those others have a good claim in contract, and credit is effectively extended to the whole group for the contract price, the respondent should take the burden as well as the benefit and we do say that the result for which the respondent contends, namely that the person who is falls between two stools, if I can put it that way, because she has the claim but she's not the contractual debtor, is left without remedy in the event of insolvency. Is
just ask, Mr. Rodman, is contractual debtor your term?
it
Or are we
is?
going
I'm
to find
sure.
it in any
No.
authority?
It's shorthand. The debtor who is in agreement,
I appreciate what
signatory
it means.
to the consumer creditor.
I just wondered, because you're using it so often, that you may have a rabbit up your sleeve. as it were.
No. It's shorthand for. And I apologise if I didn't make that clear.
No, we all know what you mean. It's just I wondered, since you're using it so confidently, that it may have a...
There's no magic to the term.
No, just wondered.
May I now take your ladyships to the OFT case, please?
Yes.
And that is tab G in bundle 1, authorities bundle 1. Now, the question in that case concerned an interpretation of section 75, but a different issue. And the question was whether a transaction within the meaning of section 75 and also arrangements within the meaning of section 12b could apply to foreign transactions in which there was no pre-existing relationship effectively between the creditor and the supplier. And the appellant banks argued not that it shouldn't apply to foreign suppliers unless they had already entered into agreements directly between them. And at that time, just as we see from one of the judgments, the market providing for the use of credit cards in the UK for foreign transactions seems to have only been limited to one provider, that was Barclaycard. But the House of Lords hold that section 75 did apply to foreign transactions, whether or not the supplier had entered into a prior agreement with the banks. It's not so much the outcome of that appeal as how the House of Lords arrived at that decision that is relevant, we say, to the approach to be taken to section 75 and its interpretation. The leading judgment was the judgment of Lord Mance, which I'll take your ladyships to in a moment, but may we start, please, at AB 159 and the speech of Lord Hope. And may I invite your ladyships to read paragraph 12.
Was this a... yes, that it was a unanimous decision, wasn't it?
Yes.
Yeah.
Well, you've picked up some of these arguments in some of your earlier submissions.
Yes, my ladies, I did preface them. So the point, in short, you have that this is where the House of Lords effectively say they look at whether the narrow scope being contended for by the banks is there, and they say, on the contrary, it's not excluded. And we draw an analogy with our case and say, well, they could have easily expressly excluded, the legislature could have easily expressly excluded the likes of Mrs. Cooper from the definition of debtor within section, for the purposes of section 75, but they didn't. May I then, the key one, if I may just re-emphasise one aspect which I perhaps didn't emphasise in my earlier submissions. At C, your ladyships will see the sentence, they are up to be understood, and that's harking back to the words, in relation to a transaction financed by the agreement.
Sorry, where are you?
At C, they are on 159, they are to be understood as extended.
Paragraph 11.
12.
Well, C
G.
is under...
Oh, so I'm so sorry, G. I'm so
There
sorry.
we go.
So sorry, my mistake. They are to be understood as extending to whatever was in contemplation when the agreement between the debtor and the creditor was entered into. Now that is important. And we say what was in contemplation when Mr. Cooper bought the holiday for the benefit of both of them was precisely the fact that they were extending credit for the package which provided for both of them, the credit being doubled as a result, and that she, if anything went wrong, she would have a claim in contract, which they know by statute. And of course we say that the advantage of Section 75 is used as a selling point for banks to persuade people to use credit cards because they get a greater level of protection than, for example, paying with a debit card. So there is nothing iniquitous, we say, in the construction for which we contend. On the contrary, we say it is in accord with the purpose that underlies the joint and several liability extended by Section 75 for consumers. If I can take your ladyships then to the leading judgment of Lord Mance, with whom the other, the speech, I'm sorry, with whom the other lords agreed, and starting at paragraph 19 on 161, please. This is a section, paragraph to which I think we both refer. If I can ask your ladyships to read the whole paragraph, it's a reference and a discussion of the Crowther report.
One has to be a bit careful, if, as you say, context is everything, because although there are some broad statements, it's one thing to extend the territorial reach of the legislation, and it's another, potentially, to extend the meaning of debtor to somebody who does not in fact owe anything.
I accept the contexts are entirely different. Yeah. I have no, of course. But I'll come on.
The challenge is slightly different.
Of course,
I can argue, you see why a failure to exclude foreign liability, if I put it that way, is perhaps more relevant to ask. Or if they wanted to exclude foreign transactions, that would be an obvious thing to do. So one can see why one asked the question, well, why didn't they exclude? It's not necessarily so obvious a question in your context, is it?
Well, I say it is because it would have been so easy to simply adopt a possessive rather than just a consumer credit agreement.
What would it have to say? His or her or their?
or relate back to the signatory debtor, or something like that. It would not have been difficult. But the words chosen are actually very wide. And so whilst I appreciate the context is entirely different, we say the principles are very similar, and the approach, we say, should be analogous. If I can take your ladyship's then, just to complete the passages from Lord Mance's judgment to page 163, please. This is do I mean 163? Sorry. Yes, 163. 163, please.
Paragraph?
24.
Yeah.
Halfway down, the Crowther Committee and Parliament, when enacting 1974 Act, did not know how the credit card market would develop, but the language of arrangements used in the Act is well capable of embracing modern relationships between card issuers and suppliers under the networks like Visa and MasterCard. And that, again, I say, when I took your ladyships to the definition of credit in section 9, is deliberately wide to be able to allow for developing markets. And
What's strange about two people being married to each other and going on holiday? That's not developing. That was well established in 1974.
No, indeed, my lady. But what was not the case before is that she would not have had a claim against the supplier in her own right. And she would not have been able to sue what the package travel regulation.
Until the 1992 regulation.
Precisely.
That's, you say, at the turning point.
Indeed.
The Rex.
Indeed. That gives her her own contractual right against the supplier. In contract. Of course, she'd have had a claim in tort or. And then over the page, please, you'll see 164, the House of Lords also refer at 26. I'm not going to ask you to read this, but they review the commentary in Sir Roy Good's text. And then lastly, at the bottom of that page, however, paragraph 29, and I invite your ladyships to read that short paragraph to the top of the next page.
What is it you obtain from this paragraph that you would
The simple point is that the fact that it would be even more onerous on a consumer to be left to their own devices to pursue foreign suppliers was a good reason for adopting the construction that they did, and finding that the purpose of Section 75 cannot have been the one for which the appellant banks contended.
But I mean, it's not a question of being more onerous, it's a question of being impossible here.
Well, indeed.
On our facts. Yeah.
Which is why impossible but for a purposive and expansive
Yeah.
interpretation of Section 75, which we say is appropriate. May I then take, lastly, your ladyships to the commentary in Good, please. This is Authorities Bundle 3, tab R. And I'm only going to take, whilst there's a great deal of the text in the authorities bundle, the first pages from 584 onwards give the background to the Consumer Credit Act, and very briefly at 587, you'll see in the first of the paragraphs that's highlighted, 2113. In short, what the Act did was replace the previous fragmented legislation with a unified and greatly expanded code, above all a regulated code, governing all forms of consumer credit and consumer hire, with a battery of provisions for the protection of the consumer, backed up by powerful enforcement machinery.
Just by the by, Mr. Audland, this is August 2022, is that correct?
Yes, I believe so.
I think we find that at 584.
We do, at the top of the page. May I take your ladyships now to the commentary on section 75, which I outlined, and it begins on 717. Liability.
I just know the provenance of this report.
I'm sorry?
I'm just looking at the provenance.
So this is Sir Roy Good on consumer credit.
Yes, but it wasn't commissioned by anybody in particular, was it?
No, this is the leading academic text on,
yes,
widely regarded as the
but
leading academic.
It was not commissioned for any particular purpose.
No.
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 So the section on section 75 begins at 717, my lady. And the provision, the critical section on the claims of third parties, as he calls it, begins at the bottom of 719 is the heading. The text is actually on 720. And it's interesting and relevant to see the title that he uses for this part of the commentary, claims of third parties, because he envisages here that some such claims are permitted by section 75 in one way or another. And so if we turn to section page 720, I'd like, if I may, to take this, because it's helpful, I hope, to break it down into sections. So the first sentence, the imposition of liability under section 75 removes an immunity which the creditor previously enjoyed by reason of the doctrine of privity. We've debated that. The second section, into the next sentence, it is not absolutely clear how far the doctrine continues to apply so as to restrict the debtor's remedy under the section, which applies where the debtor has a claim against the supplier. So the only observation there is that Sir Roy Good, or the editors of the text, do not believe that it is as clear and unambiguous as the respondent contends. We read on. Generally, this formulation causes no difficulties, but situations may occur where, on a literal interpretation of the section, there may be a gap in the statutory protection. The most obvious example arises where credit cards are issued to A as debtor and B as authorised user, but not as A's co-debtor.
But that's not Mrs. Cooper, is it?
No, it isn't. That is the situation where...
Second card holder.
Precisely. And he goes, the editors then go on to look at a second, 2 lines down, a second and probably less common example arises where the creditor extends what is apparently a debtor-creditor supplier loan to A, but it is actually B who signs the sale agreement with the supplier and who acts on the face of it as the purchaser. So that, the classic situation there would be, for example, Mrs. Cooper had been on the phone booking the holiday and was asked to put down the deposit, and Mr. Cooper had said, use my card. And the card of the what I've been calling the contractual debtor is used. She is in contract for the supply, and so you have a lacunae.
I don't know if I agree with that interpretation that you're making, to suggest that B is not still the second card holder? Because it would be usual to use different initials for a different example. So A is defined as debtor and B an authorised user. So we're still in the second card holder situation in paragraph 1.
I don't, certainly in the first of the two examples, but my understanding, I may be wrong, my lady, but my understanding is that the second example taken is not, because he doesn't use, they don't use the word an authorised user.
No, they use the same initials though, and it's usual when you're referring to the same initials having defined to whom the initials refer within the same paragraph to continue to refer to the same situation as the contextual one. But I mean, I'm just putting that out to you, Mr. Alden, so you can answer it if you feel it necessary.
That's not my understanding,
no.
My lady. I take your ladyship's point, but my understanding is that he is drawing a distinction between two different examples, because he says a second and probably less common example. So he's drawing a distinction between example 1 and example 2. They're both ultimately lead to the same legal conundrum, which is that you have the person who is not the credit card signatory is not the person in contract with the supplier.
No, but the difference is, I'm putting it at its most basic, when one of us takes a credit card and we are invited, as you say, because there's a great market in affording or offering credit and to encourage people to use credit cards, and the offer is made to add card holders to the account, what you are doing by notifying the credit card company or the credit provider by naming those other card holders is that these are people who will have use of the cards.
Indeed.
Now, you would say, well, that may be so, but they wouldn't be debtors because they're not jointly and severally liable for the debt. But I think you should frame your arguments in terms of whether I'm right or you're right.
I think I'm right, my lady, but I'll no doubt Miss O'Reilly Smith will also.
Yes, but do you have an answer to my point? If I am correct,
yes,
that these paragraphs in referring to A and B are contemplating the situation throughout where B is the second card holder, does that make any difference at all to your argument?
No, it doesn't, because we're going to go on. In fact, I mean, to look at what Sir Roy Good says are the consequences of that situation and the difficulty then that is presented, and whether A, in either scenario, has a remedy under Section 75.
Well, we're more interested in B, aren't we?
We are, but the way in which, effectively, the situation that, looking at it from either end of the telescope, the situation here that Sir Roy Good is discussing is where each party falls between two stools. One is in contract with the supplier, and one is in contract with the consumer, with the credit company. And the question is whether Section 75 should be interpreted in a way to cut through that legal difficulty and provide protection.
All right, well, I'll listen to how you put that, and then if I need to, I'll come back to it.
Thank you, my lady.
All right.
So I'll move on to the next section, which is where he addresses what they say, the editors say, is the appropriate construction. So, beginning of the next paragraph, the obvious answer is to examine the relationship between A and B to determine whether the purchase relates to their joint affairs. If so, it may be regarded as in substance a joint purchase, or at least as a purchase by B acting in part as A's agent. And that is...
Just look at that. My apologies, Mr. Ortland. There is no evidence, and you please correct me if I've got this wrong, there is no evidence in this case of Mrs. Cooper making any financial contribution.
No.
No. There's no evidence of her making a financial contribution to the credit card debt. No. And there's no evidence of her making a financial contribution to the holiday booking, and we've got the invoice.
No, I accept that. But that we say is not determinative. The reality is that the purchase, it is a joint purchase in the sense that the holiday being bought is for both of them.
You see, this sentence here, this first sentence, is predicated on the absence of any financial contribution at all on the part of A.
I say that shouldn't make...
So it's actually making the point that even if it relates to their joint affairs, it may be deemed in substance as a joint purchase, even though there's been no joint financial contribution.
Indeed, if we read on, they go on to say, in that case, A, the debtor, therefore does have a claim against the supplier. It may also be that A's interest in the claim against the supplier should be presumed in these sorts of cases in the absence of contrary evidence. And then, crucially, this, it is submitted, would not only accord with the policy of the section, but would properly reflect the fact that the creditor's business is to make advances of a type which prima facie attract liability under the section. And so I acknowledge that these two examples that are being addressed and what the solution to those examples is the inverse to our situation.
My lady's helpfully pointed out this is an August 2022 version. The judgment under appeal is August or September 2021. Has there been any commentary anywhere? Has anybody picked
We
up
looked this
on this
week,
decision
and
at all?
Mr. Archer couldn't find
Maybe
any further
fine.
commentary.
Thank you.
So, milady, what I was saying was that the situation Mrs. Cooper is in is the inverse of the two examples being explored by the editors of Good in this situation. But I say the same principles apply, namely, the policy is there to provide protection. If the policy requires Section 75 to deem the contract with the supplier to be with the credit card holder, so too, I say, should the inverse apply, namely that the debtor should be construed to be the person in contract the debtor should be construed to include the person who is not the contractual debtor, as I put it, but the person in contract with the supplier.
So, looking at these three paragraphs, they are predicated on the basis of A's ability to seek redress if B is the signatory of a contract for the supply of central heating, for example. It doesn't deal with the ability of B to claim against a credit card company if the supplier of the central heating becomes insolvent before. You're just saying
it doesn't deal with that, but effectively,
it must be read.
Mrs. Cooper, what I'm saying is that if the logic of what is being postulated here is correct, the inverse should apply to Mrs. Cooper, because the situation is the same. There is a loss of contractual nexus such that a potential claimant falls between two regimes. Contract with the supplier, contract with the credit card company. Given
this learned text, it's interesting that they haven't looked at the inverse of the problems they're posing. Exactly this point. You say the package holiday trade has taken off in a big way. I mean, unfortunately, things have happened since which have meant that many have gone out of business. And this is 2022, so they'd have been aware of that.
It is interesting, and it's a novel point.
Write to the editors.
It is a... Well, no doubt your ladyship's judgments, when you come to them, will attract further commentary.
Yes.
But we say, my lady, that the...
Yes. 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 Yes.
logically, the inverse should apply if the policy to which Sir Roy Good refers as being the driver for presuming a contract with A, then we say, so too should it presume that credit is extended to Mrs. Cooper.
Professor, because he's not speaking in such outright terms, it's all very tentative, isn't it?
Well,
it's mays
And the final sentences of the paragraph 3 that you've sidelined, on the one hand, it can be argued that CCA 74 section 75 imposes a special liability which should not be extended to cases in which it does not clearly apply, particularly if the real reason for turning to the creditor is his deeper pocket. Well, of course, it's a deeper pocket than any insolvent package operator. On the other, that if the creditor is lent on the assumption that he may incur liability for the supplier's breaches of contract or misrepresentations, a refusal to apply, and this is your point, would simply confer a windfall.
Indeed.
But as my lady says, Professor Good doesn't come to a favoured conclusion on that.
He leaves it
argument.
hanging. He leaves it hanging for your ladyship to decide, and I
And
quite
you'd say
accept
it was
that.
low-hanging fruit,
But
presumably.
what I do, my lady. But my lady, I wasn't sidelining. I was coming on to this paragraph. But
No,
because
I meant
I'd also...
sidelined in the.
Oh, sorry, I see.
Yes,
Sorry, I
sidelined on
misunderstood.
page.
Because I'd also like your ladyships to read the beginning of that paragraph as well, if I may. The first 4 or 5 sentences, 4 or 5 lines, please.
It's open question again, isn't it?
It is, and you'll see that he goes on to explore the assignment option, but I've dealt with that, so I won't go over that again.
I mean, you can say, this is a matter of interpretation, it may not matter, that there is a steer in the second paragraph in your favour.
I do say that, my lady, but I accept
which
it.
would accord with public policy and which would be consistent with the authorities.
I do.
So
I do say that.
You can take that from
Yes. And then lastly, if your ladyships would look at the paragraph that isn't sidelined, the 4th paragraph, it should be noted that underlying this analysis is a matter of definition. If indeed the advance is not financing a transaction between the supplier and the debtor, it appears not to fall within section 11(1)(b) or section 12(b) or (c), and is not in fact a debtor-creditor-supplier agreement within section 75 in the first place. Again, it is submitted that substance should prevail over form, and that if the creditor has structured his lending as debtor-creditor-supplier credit, as is not in issue here, the court should be slow to recategorise it unless it is shown that the precise identity of the purchaser had some significance for the parties. Now we say the precise identity of the purchaser does not. What matters to the credit card company is the amount of credit being extended. Of course, the identity of the signatory matters for all sorts of other reasons in the Act, but for the purposes of the burden, the liability, joint and several, imposed by Section 75, it is plainly within their contemplation that people other than the signatory to the agreement get the benefit of the credit they are extending to their profit, and they should take the burden. And that,
I do beg to carry on, please.
and we say that is consistent with the underlying policy, the purpose of Section 75.
But just taking up that first sentence, what matters is the amount of credit extended, not the identity of the creditor. The difficulty with that is that there are very precise obligations on both the debtor and the creditor and supplier under the 74 Act. And therefore, isn't it important to know the exact identity of the creditor to understand who has what obligations and to whom they are owed?
Well, to some extent, we say, by our definition, that can be established, because if the liability is confined to people who are known to be in contract with the supplier, that is a finite group. It is not infinite liability. And so that's our first answer to that. The second point I would make in relation to that, my lady, is that if that were right and definitive, then we wouldn't see the editors of Good postulating that A has a remedy where A is not in contract with the supplier. The scope goes beyond, that is what is being suggested, to achieve the purpose of the scope of Section 75, one has to go further than a black letter interpretation of sections of the words.
Taking the example that's given about A and his sister-in-law and the central heating. Oh, no, sorry, it's his sister. B, A's sister, who lives with A, and they've purchased central heating. Is there anything that we should take from the fact that it looks like Professor Good or any of the editors are trying to restrict the extent of the protection? Because why does A's sister otherwise have to live with A? That's the domestic arrangements point, isn't it?
It comes to whether in reality this is a joint purchase.
But doesn't it come to in reality whether B or A, sorry, is going to gain benefit from what B is seeking to do? It's my lady, Lady Justice Carr, has pointed out those parts of the second paragraph to which you can draw some support. But why is it necessary to, on your definition of Section 75, investigate the domestic circumstances? So going back to our scenario of Mr. Cooper, Mrs. Cooper and their children, that's one thing. But what about Mr. Cooper, Mrs. Cooper and several of their friends who've said to Mr. Cooper, could you just sub us? You've got the biggest credit on your credit card, and we'll pay you back on payday. Something like that. I mean,
the situation would, on our case, be exactly the same. Because all those members will be on the package tour contract. They will all be deemed to have their own claim for any breach of that contract.
Yes, and that's why you say if Professor Good had thought about it, he could have included this example.
Indeed.
Yeah, okay. All right. Yeah. Mr. Audland, when you come to the next part of your submissions, we're going to have a short break, only because we need to have some movement. One of us has just had an operation, so we need to have some movement.
My lady, may I just make one point,
yes,
and then that's an appropriate moment. And the short point I'm reminded by Mr. Archer is this. In this section, Sir Roy Good isn't considering personal injury claims at all.
No. Well, that's one of the interests to us, obviously,
Indeed.
as you,
so it's,
you would have devised from my lady's questions, Lady Justice Nicola Davies.
Indeed.
All right.
My lady, that is an appropriate moment.
Is it, and how are you doing at the moment?
Very well. I now am moving to deal orally with the additional argument of the respondent raised in the respondent's notice. Then I'll deal briefly with ground 2. I anticipate I'm on time.
Thank you very much. We'll be 5 minutes.
All right.
Still on.
Exactly. Obviously, interpretation. Save that. Immediately there is itself.
Whether
But then it's just that context. And also that specific section.
I need to point this out.
Well, we can do.
If not, I'll get that over lunch.
Section.
21.3. What does it say? Very different use here.
But then there's a caveat.
Yeah, I mean, it's a presumption, isn't it? So that's where? That's
21.3 of. It's on the bundle.
of Benyon.
The weight of the presumptions depends upon the context.
Yeah. Is that what it said?
Yes. It can be rebutted.
We found there is something in Benyon about words. Right, presumptions can be rebutted, but not clear. 21.3 in Benyon. Yeah. Maybe a bit on context, but I need to point that out from there. Should we just gather on? No. 5 minutes.
Sorry for that interruption, Mr. Auden, but we wouldn't have been able to concentrate if otherwise we didn't.
Not at all.
Great.
In the time available, I've established there is in answer to my Lady Justice Carr's question about Benyon and interpretation of whether one word should have the same meaning in all contexts. I will obtain copies over the lunch adjournment.
Thank you.
It is addressed 21.3 in Benyon.
Yes.
The short, from what I've been able to glean so far, the short point is there is a presumption that it has the same meaning consistently throughout the legislation.
But it's rebuttable.
But it is rebuttable, and the weight of that presumption depends on context. But I will keep my powder dry until I've read the whole thing, if I may.
Thank you very much.
And I will get copies for everyone over the short
Thank you.
adjournment. My lady, may I address now the respondent's additional argument? And that argument is this, that the respondent says that the requirement that we have to satisfy to bring ourselves within section 75 is that the appellant has a like claim against the supplier. And essentially, as I understand the argument, the respondent says she doesn't, because she wasn't the contractor to the contract, she was only a beneficiary. And we say that argument is misplaced simply by reference to the definition or the wording of section 75. So if I can take your ladyships briefly back to Authorities Bundle Volume 2 and page 334 at the first tab. The words of the section in the second line only require the debtor, assuming for present purposes we persuade you she is the debtor, to have any claim against the supplier in respect of a misrepresentation or a breach of contract. It doesn't say she needs to be the principal contractor. She does have such a claim squarely within the terms of those words by reference to the provisions I've already taken your ladyships to in the package travel regulations, namely Regulation 15 in conjunction with Regulation 2. She has her own claim in contract against the supplier by statute. And I say that is the end of that argument.
Dependent upon the interpretation of debtor.
Of course,
Yes.
of course. If I lose on debtor, we don't get to this. We don't get to this argument at
No,
all.
of course.
My lady, the second point was ground 2, which is the limitation point.
Yes. You reminded us that this is dealt with quite extensively, or not. I didn't mean that pejoratively, you understand. But you dealt with this particularly in the skeleton before Judge Simpkiss.
We did.
Yes. Would it help if we look at that
Certainly.
to see how you want to expand upon it if you do?
My lady, I don't propose. I'm very happy to take you to it. It's core bundle, tab 7, 105 to 107.
Yes. Because the real point of principle comes in the ground 1, doesn't it?
It does.
Yes.
And it may help your ladyship to have CPR 19.5 to hand as well, which is in the white book at page 667. Alternatively, if your ladyship prefers, that it's cited in full in the witness statement of Mr. Sconomilio, which is in the supplementary bundle.
Might be an easier way of getting it.
The reference to that, my lady, is tab 3 at pages 9 to 10.
Thank you.
My lady, I was proposing to give your ladyships the reference, the passages and the arguments as they were developed below, but I'm proposing to take this point relatively shortly.
Yes.
If we look at CPR 19.52 on page, it's really page 10, my lady, of if you're using the supplementary bundle. We applied below for addition on effectively two grounds before His Honour Judge Simpkiss. The first ground falls under section 2 and 3B, namely, it was necessary to add the new party under section 2 because under section 3, which defines necessary, the circumstances in which it will be necessary, under 3B, the claim cannot properly be carried on against the original party unless the new party is added or substituted as a claimant or defendant. And that is, as you'll see from section 2, that where a situation where the limitation was current when proceedings were started.
Yes.
So as soon as, what we say there is, as soon as the stay was imposed, meaning we couldn't proceed against the only defendant, it was necessary because without the addition of the new party, we simply couldn't proceed with the claim. And the second limb of our application there, my lady, is subsection 4. You'll see it begins in addition, so this is an additional limb of the jurisdiction of joinder. In a claim for personal injuries, the court may add a discretion or substitute where it directs that Section 11, this is A1, shall not apply, and Section 11 is the 3-year time limit for personal injuries claims. Or, and this is B, the issue of whether those sections apply shall be determined at trial. So the court has two options. It either directs on the evidence before it that Section 11 does or does not apply, or it says it can direct that that issue will be determined at trial when all the evidence and arguments about prejudice can be known. And in short, what we say, and what you'll see from the skeleton before His Honour Judge Simpkiss, is that at the application, the defendant adduced no evidence of any prejudice. There was no evidence before the judge. Prejudice has to be evidenced, and the prejudice in question, as is trite law, is prejudice arising out of the relevant period of delay. In other words, from the expiry of the limitation period to the issue of the application.
Just so I understand the structure, you made the application under two bases, and if you're right on ground 1, why do you need 9.54 if you were going under 9.3?
We don't, my lady. They were alternative submissions.
Right. Was there any other issue taken on 9.53B as to why, apart from the lack of merit, there was no other issue taken on this? So I don't understand why we're looking at 9.54 at all, if you're right.
Well, the whole application was resisted on the basis of 19, because I'm sorry, I should have clarified. Before the district judge, it's a little bit confusing because of the way this has evolved over time. Before the district judge, the application was not put on the basis of 3B.
Right.
It was put on the basis, was it 3C? I think it was 3C, my lady.
Which was obviously wrong.
Which was wrong. And we put it on the basis of 3B before His Honour Judge Simpkiss. And that's dealt with in our skeleton argument and indeed in my learned friend's skeleton argument. I will remind myself.
My short point is, if you're right about 3B and there's no issue on that, why do you need the extension under 4?
We say we don't. If we get in under,
just so we're clear,
they're alternative jurisdictions.
Yes, 3 is you're allowed to amend despite the expiry of the limitation period because it's necessary in the meaning of 3B.
Indeed.
4 is.
Indeed.
It may not be necessary, but the court can disapply the relevant limitation period.
3B is there, I think, because of the doctrine of relation back.
Yeah.
And and Section 35 of the Limitation Act and Rule 4 is there if you can't bring yourself within those any of those three jurisdictions under 3, you have, if you're a personal injuries claimant, you have an additional route home.
And you say, whichever way the cookie crumbles, you're doing it in the alternative.
We do.
Yes.
And we say we do fall within 3B.
Yes.
And if we need to, we say we get home under 4 because there's no prejudice. This is the primary liability admitted. The file would be available to the respondent, and no evidence was adduced of any prejudice arising out of the material period of delay. By contrast, Mrs. Cooper would lose her entire claim if the discretion is not
And you deal
exercised.
with this in paragraph 48, page 107.
Yes. So, my lady, unless I can be of further assistance, I'm not proposing to develop those arguments further orally.
But you adopt them.
I do.
Yes. Yeah. Anything further on ground 2? Thank you very much, Mr. Alden.
Thank you, my lady.
Are those your submissions?
Yes, unless your ladyship wanted me, I know we reserved the position on the small dispute between us as to statutory interpretation. It may be, I wasn't sure whether your ladyship wanted to hear just from me before deciding, or whether from both of us before deciding.
I'll come back to you if I need to.
Thank you, my lady.
And obviously, if Mr. Riley Smith raises an issue other than the one I've taxed you with, I'll come back during your response.
Thank you, my lady.
Thank you very much indeed. So, Mr. Riley Smith, you've got a hard act to follow. Somebody's kept to their time estimate.
I'm extremely grateful, as I know the court is. It is a hard act to follow, but I'll struggle on and hope that I can do as well as my learned friend. May I indicate that I would propose to open with very few words generally about our position, then outline to the court the basis of my the structure of my submissions, try and identify those issues that we consider can helpfully be developed. Pause at that moment to ask whether the court has any particular issues that it would wish me to deal with. Then launch into those, pause at 1 o'clock, come back at 2, and hope to be done by 3:30.
Super, thank you.
My lady, we appreciate that Mrs. Cooper finds herself in a predicament. She was unlucky enough to break her ankle on holiday, and then she found herself unable to recover compensation from the package holiday company because of Thomas Cook's insolvency. And it seems that even her own travel insurance didn't respond as well. And as your ladyship, Lady Justice Nicola Davies, noted when she granted permission in this case, there are likely to be other people in similar positions around the country with personal injury claims against holiday organisers under the package travel regulations, but with no solvent tour operator to sue. For although the regulations and the directive that they implement contain various provisions to address the problem of organiser insolvency, as you've seen, viz. Article 7 of the directive and regulations 16 and 17 of the regulations, those provisions don't address personal injury. They're limited to refund and repatriation. And later in my submissions, you wouldn't be surprised to hear that I will be submitting that was a conscious decision by the legislature. And the fact that they have dealt with some issues and not others is something you should take into account when considering the extent to which the Marleasing principle could be applied in this situation. Anyway, that is the predicament. But your Lordship, that doesn't mean that this court should be persuaded, as it's now invited to do by learned friends, to rewrite primary legislation in order to create a statutory claim against a partner's credit card provider. Something that we will submit was not intended by Parliament, and something that is not contemplated by the package Travel Directive. And more than that, it suggested that this should be done by changing the meaning, we will submit, of one of the fundamental terms that lie at the heart of a carefully crafted and comprehensive code that has successfully regulated consumer credit since 1974. We're grateful for the indication that you've had a chance to go through the papers, and we can see already that you've read them in depth, and you will note, therefore, our primary submission is that the word debtor in the Act its meaning is plain and unambiguous. I'm going to adopt the learned French shorthand here. It means contractual debtor, which isn't a term of art, but encapsulates what the meaning of the word is. And we respectfully submit that it's clear from Section 75, from the rest of the Act, from its context, that Parliament did not intend that statutory definition to include, as my learned friends suggest, and I'm using their words here, third-party beneficiaries of the credit extended under the agreement, such as other family members of the signatory to the contract. Your Ladyship asked about grandchildren earlier on. Plainly, they fall within the learned friend's extended definition. But as has been stated repeatedly down the years by courts at every level, the intention of Parliament is paramount. Whatever the consequences in an individual case when it comes to construing legislation. And in our submission, there is no scope for any purposive construction of something that is so clearly defined as the word debtor in this Act. I'll come on to develop those submissions in a moment if I may. Nor is the Court obliged to change the meaning of the Act by reason of the leasing principle. The learned friend hasn't touched upon it in his oral submissions, but they are a significant feature of his written submissions. Of course, the 1974 Act was not implemented by the subsequent Package Travel Directive. The Package Travel regulations were implemented by that directive in 1992. And although non-implementing domestic legislation can be made to conform, we respectfully submit that it should only be made to do so if it conflicts with the provisions of the directive. And here, for reasons that we will develop, there is simply no conflict between the directive, which, as Lady Justice Davies pointed out earlier on, regulates, between the Consumer Credit Act, which regulates consumer credit, and the directive, which provides protection to those travelling on package travel contracts.
Sorry, I just want to go back to the earlier submission. Did I hear you correctly? Although non-implementing domestic legislation can be made to conform.
A FIFA case and its explanation in two subsequent cases to which I can take you suggests that a broad approach can be taken, and you can look beyond the implemented legislation.
It was non-implementing, or are you referring to the 74 Act as being non-implementing domestic legislation? That's where I got stuck.
Sorry, the 1974 Act is simply domestic legislation.
Yes.
It doesn't implement any European directive.
Yeah.
The directive is implemented through the 1992 regulations.
Yes. So,
And the principle, the Marlisi principle, is started life in reading down into domestic legislation principles that are enunciated in the directives to ensure conformity.
Yeah.
In certain circumstances, following the case of FIFA and the various cases in the Court of Appeal, there is a broadening of the scope, and one can look at further aspects of national law in order to ensure conformity with the directive. but only in circumstances where there is a conflict.
Understood. Thank you.
Forgive me for not being clear.
No, it's my fault.
A conflict between the directive and that domestic legislation. And this is not one of those cases. And indeed, on the contrary, there are very good reasons not to change the law. Not to change the law that has stood since 1974. And those reasons have been identified by the Supreme Court in a case called Gavin, to which I'm going to take the court in a moment. So we respectfully submit there is no basis on which this court needs to build a bridge between these two consumer protection regimes. There's no conflict. In fact, there's no inconsistency. And the appellant's case we submitted is simply a bridge too far. We've set out our arguments in full. We apologise for their length in our written submissions. You'll see it in the court binder behind tab 2 from page 36 onwards. And may I simply indicate that we tend to rely on all of those arguments. But in the time available, and the hope that it persists, we propose to develop 6 of those submissions, really principally in relation to ground 1. First, with your permission, to highlight 2 aspects of the factual matrix that may have been missed, that are picked up in the judgment below, as to the parties to these 2 agreements. Second, to develop the submission that the Consumer Credit Act is a carefully crafted and comprehensive code. Thirdly, to develop the submission that there is no need for the court to engage in any purposive construction if a word has plain and unambiguous meaning. Fourthly, to develop our submission that the word debtor has such a plain and unambiguous meaning, and in that context to address you on the commentary in good to which you've been taken. Fifth, to submit the appellant has no claim against the creditor under section 75 because she was not a party to the holiday contract and therefore does not have a contractual claim for the purposes of section 75. And finally, to review, if it would assist, the authorities that establish and apply the leasing principle in this jurisdiction, to make good our submissions that it's neither engaged, and if it is engaged, there are powerful reasons why it should not operate in this case. And I wasn't proposing to supplement our written submissions on ground 2, simply take you to them, but I'll revisit that if I can. If I can find a shortcut to that, I'll come back to that after the shorter journey, if I may. I hope that I cover therefore all the points that the court would want me to deal with. If there are, of course, any other points I know that I'll be asked.
Yes, I don't think we can be held to ransom at this point because your arguments may produce further points, as Mr. Orban's did. So if you'll forgive us, we might take you down avenues which may or may not be productive.
I'm sure I will be taking down avenues, and I'm sure they'll be productive.
Or for somebody, I don't know.
My first point then is a short one. It's a point on the facts.
Yes.
Which is the parties to the various contracts. And I'm going to ask your ladyship in a second to turn to the judgment, because that's where it's all set out, and which of course is where you have the facts for the purposes of this appeal. That factual background, indeed the factual background and the procedural history were not in dispute. That's unsurprising because the only evidence before the court was from Mr. Sconomilio, I understand, the evidence that you have in the document. He's the appellant's solicitor. And only one aspect of the factual matrix requires clarification in the light of what was said in the appellant's skeleton argument, which is really the role of the appellant herself in particularly the holiday contract. Because at certain places in the skeleton argument, it would suggest that she was a joint purchaser. And our submission is that's not consistent with the factual matrix set out in the judgment under appeal. So can I ask you to turn in the core appeal bundle behind tab 5 to His Honour Judge Simpkiss's judgment and to page 80. And this is a section of his judgment headed background, unsurprisingly. He starts at paragraph 14 by saying that the factual background and procedural history are not in dispute. He has then set out what happened, but he does a helpful analysis of the parties' involvement in the various contracts from paragraph 18 onwards. The paragraph 18, he explains the parties to the credit card contract. And if I can ask you to read paragraphs 18, 19 and 20. And on paragraph 20,
Can I, sorry, Mr. Riley Smith, as I understand it, just answers given by Mr. Audland this morning, there is no issue, certainly, as to who was paying what, and he accepted that Mr. Cooper was the principal contractor. As I understand it, I thought it was in answer to a question from me.
he accepted that he was the principal contractor.
Yeah.
The judge below found, and this is paragraph 20, that the appellant had no contract with, now he said the respondent, in fact, when reading that paragraph, he must mean the defendant, that is, the holiday company, and made no payments directly from her own account, nor with any credit card of which she was the card holder.
Well, does it mean that? Because in paragraph 14,
And I was going to take you to paragraph 41, which I hope makes that point good.
oh right, okay, but it's just that the factual background and procedural history are not in dispute. The original defendant supplied the appellant with a package holiday to Salonika, pursuant to a contract or a total cost of. Original defendant agreed to supply the appellant with accommodation on an all-inclusive basis and return. That would seem to suggest that.
Well, she's one of the named parties in the holiday contract, but she's not the contractor.
I see.
And at the bottom of the page, page 20, what the judge is reflecting is the fact that as a matter of contract, she was not a contracting party to the holiday contract.
Yeah, we don't have the title page of this judgment, do we? And I don't know if we should read respondent as meaning the defendant.
This is a judgment in an appeal.
Yes, but it sometimes. Okay.
But I think I can make the point good by taking you over 2 pages to paragraph 41, 3 pages to paragraph 41,
Yeah.
page 84. And halfway down paragraph 41, the judge said this: where does Mr. Audland's broad interpretation stop if he is right? He argues under this ground that credit was extended to the claimant because the holiday was a joint purchase. As a matter of fact, there's no evidence that it was, although the whole family was going to benefit from it in the same way that they would if Mr. Cooper had bought and registered a car in his own name and with his own money. There is a joint benefit from the purchase, but that doesn't mean that it is a joint purchase. It is paid for entirely by one party only. The person extending credit is the credit card company. The credit card was not a joint one. And I simply take you to those passages to confirm the factual position as found by the judge in his judgment below.
Well, it's clear from the judgment below that those are the judge's findings, but I don't understand there to be any dispute on the financial aspect of it.
There's no dispute on the financial aspect of it. And the reason I've taken you to it is because there was a suggestion at places that there might be a joint purchase, but there is, in my submission, none.
So the position is this, so that I'm going to say it, just in case anyone is taking any exception to it. The only evidence is that the person who paid the money was Mr. Cooper. Yes. Mrs. Cooper paid no monies whatsoever.
Yes. And in fact, the evidence for Mr. Scodomilio, I understand, is that Mr. Cooper paid part of the money for the holiday on the credit card, and the remainder of the balance was paid later.
Yes.
He's silent as to how that was paid.
But by other means.
By other means, yeah.
And as a matter, I will come back to that point.
I think
Maybe
you might
just
have
curious.
to. Well, you might have to, because it raises the prospect of the principle being extended, or not necessarily extended, in the sense that Professor Good refers to the domestic arrangements, and so it often is you use your credit card because you get points on your credit card and I'll give you the money later. But perhaps you're going to deal with that
Well, I was going to come and deal with Professor Goods and
in due course.
I was going to reflect many of the comments that have already come.
All right, yeah, fair enough.
Which is this is a very different situation.
All right,
Professor Good is dealing with an additional cardholder situation, which is entirely different.
yeah, okay.
I'll come back there.
All right.
This factual point is also relevant to the submissions that I will be making in relation to the nature of the contractual claim, or the nature of the claim that Mrs. Cooper has, whether it can truly be said to be a contractual claim, whether it is in fact a statutory claim under the regulations for the improper performance of the contract, as the regulation says. But I'll come back to that if I may.
Yeah, okay.
Secondly, may I develop the point that the Consumer Credit Act is a unified and coherent code?
Well, before you do, you said in your introduction there were two aspects of the factual matrix that you wish to draw to our attention.
The judgment deals with both her involvement as a contracting or non-contracting party in the package travel contract, but also the fact that Mr. Cooper alone was
Those are the two aspects. Yeah, thank you.
contracting party. That's paragraph 18 of the judge's judgment.
Yeah, thank you.
But again, I don't understand that those matters are in dispute, but it's important to highlight.
Yeah.
My second point is that the Consumer Credit Act is a unified and coherent code. We have set out at paragraph 25 in our skeleton and the fact that the Act replaced a fragmented hodgepodge of legislation, we say, with a unified, expanded, and coherent code for regulating all forms of credit and hire. And in our submission, the nature of the code is important. The statutory interpretation is an exercise which requires the court to construe words obviously in their particular context. And the quality and the comprehensive nature of this regulatory scheme supports our submission that the word debtor, when used therein, is a carefully defined term of art within a carefully constructed scheme which has a precise meaning within that scheme.
Sorry, can you just run that past me again?
Carefully defined term of art
Yes.
within a carefully constructed regulatory scheme which supports our submission that it has a precise meaning. You were taken earlier to extract from Hansard and the speech of Sir Geoffrey Howe. May I ask you to turn back? Authorities Bundle tab 3, number 3, tab P, page 534.
This is opening remarks, it's a unified, replacing the fragmented.
And I remind you of those, I needn't take them again. But there was one point in his speech that was not picked up by my learned friend, and to which I would ask you to look. That is on page 535, at the foot of the page. Sir Geoffrey, we're in Authorities Bundle 3, behind Divider P, page 535. And in the context of my learned friends taking you to a passage up the page, in which Sir Geoffrey says the definitions in the bill are drawn as widely as they can reasonably be, and provision is made for regulations to be made under the statute, covering many important aspects. That's next door to the third or fourth paragraph. Right at the foot of the page, he addresses an important part of the Consumer Credit Act, which is Part 2. Part 2 contains many of the statutory definitions, including Section 9, which deals with credit. And what he says there is that Part 2 sets out the scope of the bill and closely defines particular types of transaction for the purposes of the bill. I will not discuss these definitions here, but no doubt they will be scrutinised carefully when the bill is being examined in committee. And we respectfully submit that it would be wrong to see Sir Geoffrey Howe in the earlier passage saying that the bill contained provisions that were meant to be broadly interpreted. He's saying exactly the opposite at the foot of the page.
Section 75 is in Part 5 of the Act.
It is,
right?
but it is. But the definition sections
No, I
in
understand.
Part 2 include credit, which is key words in Section 75. But it's all.
So are you having your cake and eating it here by raising an objection to Hansard but utilising it for your own purposes?
I don't think I've ever raised a specific objection to Hansard. I've raised the objection to the purposive construction being applied in circumstances in which the meaning is plain and unambiguous.
All right, but we'll offer you the same facility as we offered to Mr. Aldland.
And you may say this is completely unhelpful, but it provides background to the thinking behind the bill.
All right.
And to the fact that, and I stress the word closely defines, that is a hallmark of this legislation.
Yeah, okay.
In the same bundle, behind tab R, you'll find a chunk of good on consumer credit.
Yeah.
May I ask you to turn to page 586. And here the editors set out some commentary on the framework of the Act. They set out at 21.11 the parts of the Act. And from those you can see how the Act is internally organised. And then they say this at 21.12. Even from this bare list of headings, a picture begins to emerge. First, and in contrast to earlier credit legislation, consumer credit and consumer hire were brought into a system of what is now called regulation. In 1974, statutorily created regulators were still rare and confined to rarefied financial areas such as monopolies and mergers. Parliament decided from the outset that this was to be a regulated sector. And secondly, and I stress these words if I may, the 1974 Act was designed to provide a comprehensive and largely self-contained code regulating the consumer credit and consumer hire industry and almost every aspect of credit granting operation, from advertising at one end to the consequences of default on the other.
Picking up on the word largely, in what respects is it not self-contained code?
Insofar as the regulations that sit under it supplement it. But taken together with the regulations, the Act and the regulations together do provide a unified code. And I perhaps ask good ladyship to turn the page. Rather than me reading out passages, may I respectfully ask that the passage at the top of page 587 is highlighted for later reference. The particular note is paid to the passage at 21.13, which summarises it as follows. In short, what the 1974 Act did was to replace the previous fragmented legislation with a unified and greatly expanded code, above all a regulated code, governing all forms of consumer credit and consumer hire, with a battery of provisions for the protection of the consumer, backed up by powerful enforcement machinery. And in the next paragraph, I take down 4 lines. There were some significant reforms introduced as a result of the Consumer Credit Directive in 2014, which is why that sentence begins. Nonetheless, until 2014, the Consumer Credit Act remained a single, coherent code governing the related industries of consumer credit and consumer hire. And then 4 lines down. First, as already been remarked, the CCA was the sole and ultimate source of all the relevant law. Secondly, all the relevant law had some sort of statutory authority. Although parliamentary scrutiny of statutory instruments may in many cases be nominal rather than actual, the mere existence of such scrutiny affords a degree of protection against regulatory abuse. I hope that the flavour of this commentary is clear, and it's also clear why I rely upon it to support the submission that this is a comprehensive and unified code. Before we leave this passage, and for ease, may I ask you, just before you may wish to rise, short adjournment.
So we keep, my fault, we keep talking about 2014. That's the FSMA Amendment Order 2014. Sorry, yes.
Not at all. but it may be relevant also to look at paragraph 2117 on page 588. And this is under a heading, How to Read the Consumer Credit Act 1974. And this deals specifically with the approach to section 189, the definition section, sometimes called the glossary. As a preliminary, we should observe two interesting features of draftsmanship. The first is the collection of definitions in section 189. This is an extremely useful device. Section 189 not only gives definitions of its own, but also indicates all the other sections in which definitions appear. When reading the Act, it is essential to refer continually to section 189, because even words which might be assumed to have a meaning that is self-evident, such as creditor, pre-existing arrangement, security, and the like, are specially defined. The definitions are crucial to the understanding of the Act, because the exhaustive and self-contained nature of the Act may mean that an item which does not come within the often quite narrowly drafted definition in section 189 may be wholly excluded from the operation of the Act. And your Ladyships, I appreciate that this is commentary. It is, however, commentary in one of the leading textbooks, and it underpins the submissions that I will be making after the short adjournment in relation to the way that this court should be reading the definition in section 189, which is closely, in the words of Sir Geoffrey Howe, which is narrowly, in the words of Professor Sir Roy Good, and not in the manner that is suggested by my learned friend, which, in our respectful submission, goes against the scheme of the Act, which is intended to provide a tight regulatory code for these types of consumer transactions. And as the clock chimes outside, I come to the end of my second point, and I wonder whether your lady considers that an appropriate moment.
It is a convenient moment. We'll start again at 2, if we may. Just to flag up that one of the things I'd be interested in you dealing with is, and it may already be incorporated in some of your submissions, Mr. Auden started his submissions by pointing out the exceptional nature of section 675, which does away with privity of contract principles. It may come to be covered, but something I'd be pleased if you would, if you weren't going to.
Great.
Very much. All right. 2 o'clock.